2022 between Mrs. Francis Odu and one Reverend Sister Rachel Mary Okori, the principal of the Our Lady of Fatima College. 2, the registrar trustee of the Catholic of Nigeria, Port Harcourt. 3, Reverend Father J. Kabari, the Director of Education. My Lord, parties absent.
Counsel?
My Lord, with respect, I, Okora, for my Lord, I appear for the claimant. I apologize for the absence of the claimant in court, my Lord.
James? James? Where is the defendant counsel?
Well, he's not yet joined. I wanted to send a link for him now.
You didn't have the link?
Ask me to send to him now.
Is she not aware that the judgment is for today?
No, he joined yesterday. He was even aware my Lord was asking apology that he's supposed to be today, not yesterday. He was aware. He was online yesterday when my Lord apologized. That is today. But let me try to send the link to him now.
My Lord, he's here. Come on, here. Rule.
Is he here or not here?
He's here. He's Robin. He's there. Appear. CK.
With utmost respect, my Lord, CK Dibia appears for the defendant.
So what's the problem? You are not aware that the judgment is for 12 noon or what?
Lord, I did not get any notice. I was just in the court premises out of his high court matter when one James called me. When somebody called me and he said, I said, if I'm aware, I don't have any, I will have stayed. I'm not aware.
James, who was on Zoom yesterday and was aware that the judgment is shifted for today?
My Lord, that I was on Zoom with learned counsel for the claimant. I was
yesterday.
on Zoom yesterday. Yes, sir.
And you did not hear that I said it's for today? Because it was for today. They mistakenly put it for yesterday.
Lord, sir, I don't have that character of running away from my responsibilities. I have never done it and I will not start it now. I didn't know. So if I don't, I didn't know and I didn't hear. If I had heard, I would have put it in my plan to do for today. All the same, I apologize for it, sir. I was not aware.
When you are, just hold on, counsel. You came yesterday for the matter, and I said it openly that the registrar mistakenly put that one for today. I mean for yesterday. And that it was for today because I adopted it on 17th. So it still has about 2 or 3 days. That other one was expiring today. And that's why I put it for yesterday. Normally, I don't sit on Mondays. And I'm sure Mr. Okafor can testify to that. And I apologize to the counsel. So how can you be on Zoom yesterday and you are telling me that you did not hear? So how can we fix a date for judgment without you being aware of it? As a counsel, as a party's counsel.
My Lord, I apologize, sir.
You should have just apologized simply and we continue. Can't be telling me that kind of excuse. What's your name now?
My name is CK Dibia.
CK what?
CK Dibia. Dibia.
Wait, your initials are CK.
My initial is C, then K.
Yes.
The
And then
name
the surname is what?
Dibia.
Dibia?
Yes, sir.
Court judgment. I hope parties can hear me.
Yes, my lord.
Okay. I'm going to read the issue, the reliefs as endorsed on the complaint, the issue as framed in counsel's final written addresses, and then I'll go to the decision part. I'm leaving out my summaries on pleadings and arguments and then submissions of counsel. But they are in the judgment. When you pick your copies, you will see them there.
Stop, please.
Okay. Court judgment. On July 26, 2022, the claimant sued the defendants by way of complaint, seeking for the following reliefs. 1. A declaration that the purported termination of the appointment of the claimant by the defendant by a letter dated 31st January 2018 is null and void and of no effect whatsoever. 2. Another setting aside the purported letter of termination dated 31st January 2018. 3. Another directing the defendant to reinstate the claimant and that the claimant resumes work immediately. 4. Another directing the defendant to pay the claimant the sum of 75,534 naira 14 kobo as monthly salaries from 1st February 2018 till judgment. 5. Another directing the defendant to pay the claimant the sum of 60,000 naira as balance payment for holiday work for the month of August 2017. 6. The sum of 20 million naira as general damages for wrongful termination of appointments. In the defendant's final written address at page 183 of the court record, Their counsel raised the following issues for the court's determination. 1. Whether determination of the claimant's employment is wrongful. 2. Whether determination of the claimant's employment by the first defendant can be declared null and void and the claimant reinstated, having regard to the master-servant's employment relationship between the parties. And 3. Whether the claimant has satisfactorily proved her case to be entitled to the relief sought. In the claimant's final written address at page 222 of the court record, our counsel raised the following issues for the court's determination. 1. Whether the defendant's education policy and operational guidelines for schools in the Catholic Diocese of Port Harcourt, first edition 2014, has been incorporated by necessary implication into the claimant's contract of employment and forms part of the claimant's contract of service, thus binding and enforceable against the defendant. 2. If the above question is answered in the affirmative, whether the defendant can lawfully terminate the employment of the claimant without due process as entrenched in the defendant's education policy and operational guidelines for schools in the Catholic Diocese of Port Harcourt, first edition 2014. 3. Whether the claimant's employment with the defendant was properly terminated in accordance with laid down procedure for termination of employees of the defendant's schools as entrenched in the defendant's education policy and operational guidelines for schools in the Catholic Diocese of Port Harcourt, first edition 2014. 4. Whether the termination of the employment of the claimant was wrongful and accords with international best practice. 5. Whether the claimant is entitled to all the reliefs against the defendant. And 6. Whether the claimant is entitled to general damages for wrongful termination of her contract of employment. Are the parties hearing me?
Yes, my lord.
Okay, because I can't see you again online.
We are here, my lord.
Okay. I can't see the other counsel, I think for defendant, right?
Yeah,
Yes, I now go to the decision part of the judgment. I've gone through the facts of this case, the content of the parties' evidence and exhibits. I have also considered the written arguments of counsel to the parties, together with their cited decided authorities, both statute and case laws. I have also considered the written argument of counsel to the parties, together with their cited authorities, both statute and case laws. From all of this, I am of the considered view that the following are issues that this court will resolve between the parties. 1 is Exhibit C9, the education policy and operational guidelines for the schools in the Catholic Diocese of Port Harcourt, first edition, 2014, part of the claimant's contract of service. Was the termination of the claimant's employment unlawful, wrongful, and accords with international best practice? Can the claimant be reinstated? 2. Is the claimant entitled to payment of salaries in lieu of notice? Is she entitled to the sum of 76,000 naira, 76,534 naira 14 kobo as monthly salary from February 1, 2018 till the date of judgment? Is she entitled to the sum of 60,000 naira as balance of her payment for holiday work for August 2017? Is she entitled to the sum of 20 million naira as general damages for wrongful termination of appointment? Now, resolution of these framed issues. By way of introduction, counsel to the defendant argued that in master and servant relationship, now known as private employment relationship, the employer can determine the employment of its employee for no reason and for bad reason. He went on that the reason the defendant gave in the termination letter is immaterial once they complied with the terms and conditions of the employment in the determination of the employment. Let me restate here that in the current labor jurisprudence globally, it is bad labor practice for an employer to terminate the employment of its employee for no reason or for bad reason. The labor standard now is that determination of an employment, even in private employment, like the one at hand, must be for good or for valid reason that is related to the conduct of the employee's duty under the employment. See Determination of Employment Convention 1982, number 158, and Recommendation number 166. Even though the convention is not yet ratified by Nigeria, this is the current international labor standard and international best practice that this court is enjoined to observe in cases like the one at hand. Furthermore, see the provisions of Section 7 sub 6 of the NIC Act 2006 and Section 254C1 F and H of the Constitution of the Federal Republic of Nigeria as amended by the Third Alteration Act 2010. Additionally, I refer to some unreported cases of this court, and you see it in the judgment. Furthermore, contrary to the submission of the defendant counsel that the reason given in Exhibit D3 for terminating the claimant employment is immaterial, insofar as the first defendant had power under the letter of employment Exhibit D1 to terminate the employment once they duly satisfy the terms and conditions therein. This is a misconception of the law, in my considered view, because the requirement in labor law now is that whenever a reason is given for the termination of an employee's employment, that reason must be justified by the employer in terminating the said employment, even in private employment. In the instant case, however, the claimant is not challenging the reasons given by the defendant for terminating her employment. She is only challenging the procedure adopted by them in the determination of her employment. Counsel to the claimant urged the court to hold that the disengagement of the claimant was wrongful and null and void, and cited Part 2, Section 7, Sub 6 of the National Industrial Court Act 2010 in support. There is no law known as National Industrial Court Act 2010. The claimant counsel is hereby advised to check his citation very well before presenting it to court. Now we go to the merit of the case. Issue 1, as framed above, I take it step by step, is Exhibit C9, the Educational Policy and Operational Guidelines for Schools in the Catholic Diocese of Port Harcourt, first edition 2014, part of the claimant's contract of service. Exhibit C9 is a handbook on educational policy and operational guidelines for schools in the Catholic Diocese of Port Harcourt, and it was published in year 2014 by Educational Board of the Catholic Diocese of Port Harcourt. See pages 300 to 323 of the court record. This exhibit inter alia regulates the staff's appointment, staff structure, termination and discipline of staff in schools in the Catholic Diocese of Port Harcourt. The claimant maintained that this exhibit is part of the document that regulated her employment with the defendant, while the defendant contended that the exhibit does not apply to the claimant case because it is not part of the document that governs her employment. Exhibit C1 before the court is the letter of employment of the claimant. It was issued to the claimant on February 4, 2015, and her employment took effect from February 5, 2015. See page 22 of the court record. Even though it is not mentioned in Exhibit C1 that Exhibit C9, which was effective in 2014, formed part of the terms and conditions of the claimant's employment, the claimant supported the argument of the applicability of Exhibit C9 with the content of Exhibit C6 at page 34 of the court record. Exhibit C6 is on the letterhead paper of Catholic Diocese of Port Harcourt, Department of Education. It is addressed to the principal, Our Lady of Fatima, PH, dated 19/2/18, titled Termination of Mrs. Francis Dio's appointment, and signed by Reverend Father J. Kabari, Director of Education. Exhibit C6 states, and I quote, following a petition submitted to this board by Mrs. Francis Dio, as well as my discussions with you on the matter, I direct that Mrs. Francis Dio be retained as a staff in your school till further notice. This directive is born of the fact that this board retains the rights as vested on her by the local ordinance to employ/ratify the appointment/dismiss member of staff of the association schools. If by any chance the case has been different, this has been based on the erroneous impression that the management of your school is not under the Diocesan Education Board. End of quotation. The defendant, on the other hand, vehemently challenged the position of the claimant on Exhibit C9 and supported the argument with the content of Exhibit D4 at page 177 of the court record. Exhibit D4 is on the letterhead paper of Diocese of Port Harcourt, Bishop's House, 31 Harbour Road, Port Harcourt. It is dated July 2, 2008. Addressed to Reverend Father Charles Agu, Director, Diocesan Education Board. It is titled Re Fatima College. It is signed by Most Reverend A.O. Makozi, Catholic Bishop of Port Harcourt Diocese. Exhibit D4 states, and I quote, you may recall that Catholic education in our diocese has a definite mission in the same way. When I set up the Diocesan Board of Education, it was with a clearly defined focus. You may also notice, for instance, that even though Sacred Heart Minor Seminary is a post-primary institution, it has not come under the purview of the Education Board. I exercise direct supervision over its administration, and I have valid reason for that. Pope John Paul II Secondary School at Bori was established as a unity to relieve the constant pressure in the seminary for education of those without vocation to the priesthood. Fatima College was also established as a unity school for girls whose parents, Catholic or non-Catholic, seek quality education for their children. I do not want the board to be distracted from the importance and urgent task of making our Catholic schools particularly the newly returned ones, functional and effective. I find the management of Fatima College quite exemplary. I have now decided to exercise direct supervision over the affairs of Fatima College until further notice. I hope this will leave the board free to now concentrate on those schools that have been proven problematic. End of quotation. From the content of Exhibit C6 and D4 reproduced above, the Lord Bishop, Most Reverend A.O. Makosi, Catholic Bishop of Port Harcourt Diocese, who set up the Diocesan Board of Education in Port Harcourt, made it very clear as far back as July 2, 2008, via Exhibit D6, that via Exhibit D4, that Fatima College, the defendant college, just like the Sacred Heart Minor Seminary, a post-primary institution, and Pope John Paul II Secondary School at Bori are under its direct supervision, and that the three institutions are not under the control of the Catholic Diocesan Board of Education in Port Harcourt, which is set up. There is no evidence before the court that Exhibit D4 was reviewed by the Diocesan Board of exhibit that there is no evidence before the court that Exhibit D4 was not received by the Diocesan Board of Education in Port Harcourt, who published Exhibit C9, the Educational Policy and Operational Guidelines for Schools in the Catholic Diocese of Port Harcourt. In the circumstance, I find that Exhibit D4 has been in the record of the Catholic Diocesan Board of Education in Port Harcourt since July 2008. The author of Exhibit C6, Reverend Father J. Kabari, Director of Education, apparently a staff of the Catholic Diocesan Board of Education in Port Harcourt, apparently is a staff. In other words, Reverend Father J. Kabari is junior to and a subordinate of the Lord Bishop, Most Reverend A.O. Makosi, Catholic Bishop of Port Harcourt Diocese, who set up the Catholic Diocesan Board of Education in Port Harcourt. This means that Reverend Father Kabari's decision, action, and direction cannot override that of the Lord Bishop, Most Reverend A.O. Makosi, and I so find. Furthermore, I find that the claimant did not show the court by evidence that the Lord Bishop, who set up the Catholic Diocesan Board of Education in Port Harcourt, has changed his decision to continue supervising Our Lady of Fatima College, Port Harcourt, directly. From the evidence before the court, I find again that the defendant college is not under the supervision of the Catholic Diocesan Board of Education in Port Harcourt. Consequently, I hold that Exhibit C9, the Education Policy and Operational Guidelines for Schools in the Catholic Diocese of Port Harcourt, formulated by the Catholic Diocesan Board of Education in Port Harcourt, is not applicable to this case because Our Lady of Fatima College, Port Harcourt, where the claimant worked, was not under the control of the board, but under the Lord Bishop, Catholic Diocese, Port Harcourt, directly. I further hold that Exhibit C9 is not part of the claimant's contract of employment before the court. As court pleases, right?
Court pleases.
Yes. If you say as court pleases, it means you are listening and you are following it. If you don't talk, it means you are not listening. You are not following me.
No, we
and
are
that will
following
not
you.
be fine at all.
No, we are following.
Okay.
Yes, my lord.
Was the termination of the claimant's employment unlawful or wrongful or accords with the international best practice? The claimants did not show any law that the defendant contravened in terminating her employment. There is no point in the circumstance to belabor this question. I find and hold that because it is not shown that the defendant contravened any law by the way the claimant's employment was terminated by them, the determination of the claimant's employment in this case is not unlawful.
As court pleases.
Is the termination of the claimant's employment wrongful? The answer to this question would be in the affirmative if the termination contravenes the terms and conditions of her employment as stated in her letter of employment exhibit C1 at page 22 of the record. It is strict law that in private contract of employment, it is the terms and conditions of the employment stated in the said document which created the relationship that governs the relationship between the parties. Two decided authorities are referred to there. In the case of Ovive versus Delta Steel Limited, citation supplied, the court held that in a master and servant relationship now known as private employment, the master/employer has unfettered right to terminate the employment of an employee, but in doing so, he or it must comply with the procedures stipulated in their contract, which is Exhibit C1 in the instant case. Paragraph 5 of Exhibit C1 is to the effect that if that Exhibit C1 is the letter of employment, is to the effect that if either of the parties want to put an end to the contract therein, the other party is entitled to 30 days notice or payment of a month's salary in lieu of notice. That is the only condition for the determination of this contract between the parties in the instant case. And I so find.
As court pleases.
Exhibit C5, which is the letter of the determination of the claimant's the letter of the claimant's employment, it is at page 33 of the court record, and it is titled Termination of Provisional Appointment. Paragraph 3 of this exhibit states that, and I quote, "You are hereby paid a month's salary in lieu of notice, 76,534 naira 14 kobo. See also Exhibit D3 at page 176 of the court record. The termination letter is dated and effective from January 31, 2018. The claimant argued that she was not paid any salary in lieu of notice, and the defendant did not prove before the court that they actually paid her the said money as argued as agreed in the terms of the contract of employment. Consequently, I find and hold that the termination of the contract employment by the defendant with immediate effect without paying her a month's notice, a month's salary, without paying a month's salary in lieu of notice is wrongful, and I so hold.
As court pleases.
Was the termination of the claimant employment in accord with international best practice? This court is not sure of which of the international best practices that the claimant and her counsel had in mind when they listed this as one of their reliefs, since the court is not allowed to speculate on this by law, this issue is discontinuous and dismissed in this judgment.
Score, please.
Can the claimant be reinstated in this case? The contract of employment between the parties is a private one. Even though the termination of the claimant's employment is wrongful as held above, she is not entitled to reinstatement. This is because it is only in employment with statutory flavor, which is held to be illegally determined, that the court can, which the court, let me take that again. This is because it is only in employment with statutory flavor, which is held to be illegally determined, that the court can order reinstatement of the claimant. Consequently, I hold that the claimant in the instant case is not entitled to reinstatement, regardless of the fact that the termination of her employment is said to be wrongful.
Score, please.
I now go to issue 2 as framed. So I take them one after the other, the sub-topic there, sub-questions. Is the claimant entitled to payment of a month's salary in lieu of notice? In paragraph 5 sub 3 of the statement of defense and paragraph 13 of the evidence of their witness, we are ready to pay the claimant a month's salary in lieu of notice whenever she is ready to take it. In other words, it means that the defendants have not paid to the claimant a month salary in lieu of notice for terminating her employment with immediate effect, and I so find. In the circumstance, I hold that the claimant is entitled to be paid by the defendant jointly a month's salary in lieu of notice in line with the terms of our employment in Exhibit C1.
Score, please.
Is the claimant entitled to the sum of 76,534 naira 14 kobo as monthly salary from February 1, 2018 till the date of judgment? Since the claimant is not entitled to reinstatement as held above, because her employment salary. Did you hear what I read out?
No, my lord, it must be the network, sir.
Yes, okay. That's on the payment of a monthly salary from February 2018 to the date of judgment. I take that again. Since the claimant is not entitled to reinstatement as held above, because her employment was not with statutory flavor but a private one, I hold that the claimant is not entitled to payment of her monthly salary with effect from February 1, 2018, after the determination of her employment with the defendant.
Score, please.
Is the claimant entitled to the sum of 60,000 naira as balance of her payment for holiday work for August 2017? This relief, in my considered view, is a special damage being claimed by the claimant. This claim for the sum of 60,000 naira is said to be the balance of her payment for the holiday work for August 2017. The question is, how did the claimant arrive at this amount? What was the original agreed sum, or how much was paid to her by the defendant for the work? The court cannot answer any of these questions from the claimant's evidence before the court. This means that the claimant want the court to speculate on these questions which the court is not allowed to do in this judgment. In the case of Oyora versus Oyora and another citation supplied, His Lordship Rose Bible, GSC retired, held entirely, and I quote, special damages must be specifically pleaded and strictly proved by the claimant. To succeed in a claim for special damages, the claimant must plead the special damages and give necessary particulars and adduce credible evidence in support. The claimant must satisfy the court as to how the sum claimed as special damage was quantified. Special damages are awarded for actual and exact losses suffered. End of quotation. In the instant case, the claimant failed woefully to prove these special damages as held in the case cited above, and I so find. Therefore, I hold that the claimant is not entitled to claim from the defendant the sum of 60,000 naira as balance of her payment for holiday work done for August 2017. And this claim is accordingly dismissed.
As court pleases.
Is the claimant entitled to the sum of 20 million naira as general damages for wrongful termination of an appointment? The law is that once a breach of contract is established, damages follows. General damages are those losses that flow naturally from the Adversaries Act. They are awarded by the court to assuage the loss caused by the said act of the adversary. They are generally presumed by law, as it needs not be pleaded or proved. Some decided authorities are referred to there. However, in the instant case, the claimant failed to prove the substantial part of her case against the defendant to the satisfaction of the court. Therefore, she is not entitled to the general damages so claimed, and I so find and hold.
As court pleases.
On the whole, I hold an order as follows. I hold that Exhibit C9, the Educational Policy and Operational Guidelines for Schools in the Catholic Diocese of Port Harcourt, first edition, 2014, was not part of the claimant's contract of employment. 2, I hold that the termination of the claimant's employment was not unlawful, neither did it contradict the international best practice. 3, I hold that the termination of the claimant's employment I hold that the termination of the claimant's employment as she was not given the required notice prior to the determination, neither was she paid I hold that the termination of the claimant's employment was wrongful as she was not given the required notice prior to the determination, neither was she paid her salary in lieu of notice. 4, I hold that even though her termination was held to be wrongful, she is not entitled to be reinstated. 5, I hold that the claimant is entitled to payment of a month's salary in lieu of notice of the termination of her employment. 6, I hold that the claimant is not entitled to payment of the sum of 76,534 naira 14 kobo monthly salary from February 1, 2018 till today. I hold that that's 7 now. I hold that the claimant is not entitled to be paid the sum of 60,000 naira as her balance for holiday work that she did in August 2017. And this claim is accordingly dismissed. I hold that the claimant is not entitled to payment of the sum of 20,000 naira general damages, and this claim is also dismissed. Judgment is entered accordingly. I make no orders to cost.
Next call, please. Lord, we must, on behalf of the court for this well for his
The Lord speaking on behalf of the defendants. We thank the Lord for the industry in the time taken to distinguish the cases and the one that is also before the court. We are sincerely grateful, sir. Once again, my apologies, sir.
Just hold on, just a minute. I'm still putting my entries together. So, yes, thank you very much. By next week, you get copies of your judgment by God's grace.
We are grateful, sir.
Okay. So we can now leave. Thank you.
We are grateful.